ready?
We are ready.
Okay, so we're on. So right now I want to call to order at 5:30. This is the time set for the hearing 2 appeals from the Planning and Zoning Commission, Resolution 2021-008. The City Council is sitting as a Board of Adjustment. Sergeant Mesmer, would you lead us in the pledge, please?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And Madam Clerk, would you call the roll of the Board of Adjustment, please?
Yes. Buckline,
Present.
Osenga,
Here.
DeMoss,
Here.
McClure,
Here.
Casagrande. Not here.
She's excused.
Okay. Cease,
Here.
Mayor Terry.
Yes.
You have a quorum, Mayor.
Thank you. So, we need to please get Carol Griswold on the phone.
Yes, ma'am.
Terry, do I have to say that?
We'll get.
Okay.
Hello, this is Carol.
Hi, Carol. You're on the phone with the Board of Adjustment. We're just calling to order, and we're going to be going through some preliminary language and then adopting the agenda. But we just want to have you online for when we're ready for your testimony.
Thank you.
Thank you. And we can hear you clearly, and let me know if the volume needs to be adjusted on our side.
I hear you clearly.
Thank you. So right now it is 17:32. This is the time set for the hearing of the first of 2 appeals regarding Resolution 2021-008, and I'll read that title into the minutes. A resolution of the Planning and Zoning Commission of the City of Seward, Alaska, granting a conditional use permit to SeaView Community Services to operate recovery housing, substance abuse treatment center, and medication assistant treatment clinic within a 4-unit multifamily dwelling on Lot 21A, Block 25, original Townsite of Seward, located at 402 2nd Avenue within the Auto Commercial Zoning District. This appeal was brought by Ms. Carol Griswold at approximately 6:30. The second of 2 appeals will be heard. The second appeal was brought by SeaView Community Services. When sitting as a Board of Adjustment and conducting this hearing, Council is acting as a quasi-judicial body. The Board of Adjustment may affirm, modify, vacate, set aside, or reverse the Planning Commission's decision, or may send the conditional use permit application back to the Planning Commission for further proceedings. So as mayor, I will serve as the presiding officer of the Board of Adjustment. The Board of Adjustment is comprised of Seward City Council members. And so also in attendance we have the City Attorney, Attorney Brooks, we have the City Clerk, and we have Community Development Director, and also the Assistant City Manager. Councilmember Casagrande previously gave notice that she was recusing herself from participation in both appeals. She identified a substantial financial interest and bias in the appeals due to her status as a real estate agent in the pending sale of Lot 21A. So Ordinance 2021-004 defines substantial financial interest as a financial interest that would result in a gain or a loss exceeding $1,000 in a single transaction or $5,000 over a course of a year. Based on her disclosure and the code definition of substantial financial interest, I agree. I've previously agreed and agree now that she is disqualified and her absence is excused as noted during the roll call. If the board wishes to override this ruling, now is the time to make the motion to do that. Okay, hearing none. Now does the board member have any matter to disclose regarding disqualification, participate in either appeal? And this is not asking about ex parte communication. That will be next. Right now, disqualifying matters would include a direct or indirect substantial financial interest that I've already defined in the outcome or inability to sit as an impartial decision maker due to bias in favor or against one of the appellants in either appeal.
Is that where I go?
Well, do you have? I think
I don't get any financial gain.
Okay, so I think what you were getting to that part
Okay.
next. So, so I'll just pause again. and just make sure that no one has a substantial financial interest to disclose. Okay, thank you. So, the next thing that I'm asking is, has any board member had any ex parte contact with any person relating to either appeal? And so I'm going to start that conversation. So I'm going to pass the I'm going to pass that to the vice appeal chair, and I am going to disclose my ex parte contact and the details. So prior to the P&Z meeting, I called SeaView because of their request to support their application. I spoke to SeaView Executive Director and the Clinical Supervisor. I called them to discuss a previous meeting I attended with them regarding the concerns and negative impacts to the neighbors of their recovering housing fourplex. I asked what SeaView had done to address. Specifically, we discussed the fence they built and the further training they provided to their staff to help control the negative behaviors of their clients affecting those neighbors. So that's my first one. I have 3 in total. My second one is I had a call with the Johnsons following the P&Z meeting regarding their concerns. I let them know to keep the director and clinical supervisor's information and to just call them directly with any issues because for them to track and address. And then finally, I had a call from Commissioner Ambrosiani asking if there was an appeal filed if there was already an appeal filed in the process, and I directed him to the clerk for any updates or information. And I just, I'll turn that over to you then.
So I would vote that you do not have a significant conflict of interest.
So I'll just say that I don't believe that those ex parte communications, I do feel impartial coming into both of these appeal hearings.
Now, does either party in either appeal wish to raise any issue regarding disqualification of a board member to participate?
So now's the opportunity for either appellant to say if they have an issue due to those ex parte communications. So I'll just check with Carol. This is your opportunity, and then also with SeaView representatives.
Thank you, Christy. Would you clarify if this is just pertaining to your ex parte contact or others?
It's just pertaining to mine, and we will ask the question after each person when they disclose their ex parte.
Very good. I have no problems with yours.
Hi, my name is Sienna Caruso, and I'm an attorney for SeaView Community Services. I'm curious, could you provide a little bit more information about your conversation with Commissioner Ambrosiani and his interest in the appeal?
Yeah, we didn't go into any details. He had just, I don't know if he heard, but he asked me if I knew if it had been appealed. And I said I hadn't heard, and then he said, well, what would be the process? And I said, you just have to contact the city clerk. I wouldn't have any of those details. It was a very brief conversation.
Do you know what aspect of the commission he was interested in being appealed?
No, and I'm sorry, I don't know if he was asking for him to appeal it, or if he was just asking from the process if it had been appealed. In general, I don't know what his angle was because we didn't speak it in great length.
Thank you. Could you provide a little bit more information about the call you had with the Johnsons?
Sure. So they had said that they had some concerns, and based on my previous conversation with SeaView, I just suggested that if they had any concerns that they moving forward, that they could just call the SeaView director or the clinical supervisor in charge of the fourplex if they had any complaints or concerns.
Did they describe what kinds of concerns they had?
Yeah. Do you want me to talk about those?
Yes, if they shared them with you.
Yeah. So they had concerns about potentially drugs being left in the neighborhood. They had concerns about their children being exposed to potential criminal activity or people walking through their yard or criminal activity in the neighborhood.
Did you you provide any response, either in agreement or against their concerns?
No, I said, that was it. I said, yeah. So let me just check what you're, like, did I say, oh yeah, I agree with you, that's gonna happen, or I don't think that's gonna happen? Is that
Yes.
your question? I didn't say anything like that. I said, oh, you know that, I relayed previously that I had a conversation with Chris at the other, regarding the other location, and that their response was that they wanna hear from neighbors so that they can address things, and so they should, you know, they could get her number and the clinical supervisor's number off that flyer, or off that letter that was sent out to the community, and I directed them to that contact information.
So what exactly did you share with the Johnsons about your communications with CVU?
In regard to the previous fourplex? Just that those neighbors had had some issues, and then once SeaView had heard of them, they were able to address, and they said that they welcomed hearing from neighbors. Previously with that, they hadn't heard any complaints until we met with them, until I was part of a meeting with them, and that once those were brought to their attention, that's how they wanted the process to go. Like, they wanted to hear about those things ahead of time.
When was this meeting?
When did we meet? I think it was, I don't know if it was 8 months ago, 6 months ago. Chris would know. But it was quite previous to this application. It was in 2020. I
Did
believe.
you have direct communications with neighbors of the other facility on 6th Avenue regarding concerns related to this?
I did.
What was the extent of those discussions?
They felt, do you really want me to talk about that?
Well, I'm interested in how you were involved in, I guess, facilitating or participating in those discussions.
Well, those neighbors contacted me in my role as mayor and asked for assistance because they felt like they weren't getting anywhere with SeaView. And so they invited me to attend a meeting that was set up with SeaView.
Okay. Have you had any other communications with any other residents regarding the facility at 402 2nd Avenue?
This new application? No,
None at all.
none at all.
We don't have any concerns at this time with regard to participating in the appeal, but if additional information comes to light, then we reserve our right to challenge your involvement.
Okay, I mean, I don't know if that's, I mean, are they able to do that with a quantifier?
Yes, they can say that,
Yeah.
obviously. Whether it would have any legal impact is another question, but it's not unusual for people to say, I'm reserving in case, I find out something completely opposite of what you just said, so
Okay.
that's perfectly okay for somebody to do that.
Okay, so, no objections have been raised, and I'll take this back. So, is there any other board member had ex parte contact with any person relating to either appeal?
Is that my turn now?
It's,
I should say.
Councilmember Cease?
Just so everybody knows that I was on the board of directors at SeaView Community Services for many, many years. I haven't been now for about 10, and I knew that the sale, just by word of mouth on the street, that they had sold that building, and then I heard it was sold to SeaView, and I talked about the appeal with one of the board members, and she said, sorry, I can't talk about it. I said, okay, I will call the director, and she said she won't be able to talk about it either. So I thought there's no sense calling anybody about it because I wasn't going to get any questions, and then the appeals came out. I've never had any financial gain.
Those things that happened prior to knowing it was going to be appealed, so I think there would be more comfortability if you would disclose all your conversations surrounding this issue.
Okay, I really didn't talk to anybody around their neighborhood. I talked to some of them on First Avenue, and they were in favor of having it. And I suppose I was too at the time, but you know, there are more concerns brought up now. But I don't remember talking to anybody that, I mean, just the ones right in my neighborhood. You know, a couple of them there, we talked about it. But as far as I didn't go to anybody on the commissions, and I didn't go to anybody at SeaView other than asking one of them, and she said there was absolutely no way she could talk about it. And I don't know, maybe Carol has something else to say on that, that's fine, you know.
Carol, did you want to ask Councilmember Cease further questions regarding her ex parte communications?
Yes, I would, please. I'm searching my text messages. The clerk may recall that I sent out a request that all council members be advised that for any decision made by planning and zoning, they might have to serve as Board of Adjustment, and they should not be lobbying people to support one side or the other. They should not have ex parte communication. And I did that because I was told that.
So Carol,
Councilmember
I'll let
Cease
you
was
know that that
talking.
email went out. So I wonder if you have any questions specifically for Councilmember Cease, and I can ask some more questions too, but I'll give you the opportunity.
I think that demonstrates evidence that there was ex parte communication occurring, and I was trying desperately to stop it.
Mm-hmm.
And then after that, I sent it out as please share with all the council, and then you all received that, I assume, and then Brenda sent out a more formal one advising council members not to have ex parte communication. I wouldn't have done that if I felt there wasn't something happening. So that's why I request respectfully that Cheryl Cease excuse herself, and also due to the bias of having served on the board of directors, I don't think she can really be impartial.
Councilmember Cease, about how many people do you think you spoke in favor of the?
Was this before the meeting that they had to start with? Or was this after the meeting and during the time that for the appeal to be in?
You know, I'll look to the attorney, but I think at this time we're supposed to disclose everything regardless of the timing.
Well, the email that I received did come from Brenda, but I already knew I wasn't to talk about it.
Yeah. Let me
Because
check.
one of the members of the Seaboard told me that.
Let me check with the city attorney.
Well, the underlying issue, which isn't necessarily restricted to simply talking about it with people within the community, is whether any member of this board, you know, whether you all can be unbiased. That's the responsibility you have when you serve as a member of a Board of Adjustment, is to be unbiased. So communications are part of it, and they certainly should be disclosed as they relate to this particular proposed use. So it could be before the CUP application was submitted, because the conversation related to this exact property in this location and what SeaView's plans were to do with that property.
So that is, so anything regardless of the timeline to that use, if you could disclose all those ex parte communications.
I did have one with Chief Nichols, because I'd heard that people were saying they were having trouble, the ones over on 6th Avenue, the 6th or 7th. Anyway, and I asked him, and he said, he told me directly that they hadn't had any trouble. But now I read that they had, but he told me there wasn't any trouble over on, and that is when I called one of the girls that was against it. And I said, I hadn't heard that. So I did talk to somebody that has, do I say who?
it's,
Okay, Marie Gage, I talked to her on the phone, and I said that I had asked the chief if there was any trouble over there, and he had told me no, and so when she said there was, she knew for sure. I said, well, I just asked the chief, and he told me no, so I didn't know which one to believe. And at the time, I believed the chief, but now that I've read other things, heard other things, then I guess he just didn't want to disclose something that probably at that time wasn't any of my business.
okay, were there any other ex parte communications?
Not that I know of, you know, if you're just in conversation with somebody that they're gonna do it, I may have talked about it, but I don't remember anybody that I said that I wish you would go this way, I wish you'd go that way. I don't. Because anybody I talked to had nothing to do with the council or planning and zoning. It was just a neighbor or two.
I mean, I feel like I have enough information to, make the determination unless, Attorney Brooks, you have anything to add to that?
No, there is this fundamental question as to whether any board member is, comes into this with a bias that predisposes them to find one way or the other.
Okay. Well, I'm gonna rule that you don't have a bias and you can stay on the, Board of Appeals. Is there anyone on the board that wants to, talk about overruling that? Okay, thank you. Is there any other board members that would like to, disclose any ex parte contact? We'll let you go.
Well, it's not really ex parte. I just feel I should disclose. I watched the meeting when it was happening, the meeting that made this decision, because that was before we knew that we shouldn't even know about it. But the transcript is in our packet, so there was nothing other than what was, I mean, it's on YouTube now, but that's all I did.
So I might just check with you. You've had no, person-to-person, discussions about this issue?
No.
Okay, I'll turn to Carol Griswold first and ask if you have any objections to Sue McClure staying on the board.
No objection.
Thank you. I'll turn to SeaView and see if you have any objections.
No objections.
Okay, thank you. Then I'll determine that you don't have any issues, that you are not disqualified from the Board of Appeal. Is there anyone else? Vice Mayor Buckland?
I was here on the night of the meeting because there was another thing that I was interested in. I was sitting outside. I did witness one of the constituents raise his voice and then run out and then leave the room. Prior to that meeting, I had a phone call with SeaView, Sarah, and I can't remember his name right now, because they had asked me if I had any questions about what was coming up to planning and zoning, and I did have some questions. I know that there had been citizens who were concerned about the other recovery home, and I had asked them about what their plans were and how they were going to mitigate what any of their other people's concerns were, and I know that they had talked about some of the solutions that they had did at the other property by building a fence and having their residents on the other side of the fence and not like really outside. However, I do understand coming into this not being biased and really listening to both sides of the argument and what is laid down in the rebuttals and the complaints, and I do feel that I can make a unbiased decision.
Okay, thank you. And I'll start, this time I'll shake it up and start with SeaView. Do you have any concerns or further questions for Vice Mayor Buckland?
No, not this time.
Thank you. Carol Griswold, are you fine if I use your whole name? Would you prefer I say Miss Griswold? Carol, what's your preference? I'm sorry to keep stumbling over that.
You can keep it brief and just call me Carol.
Okay, thank you, Carol. Carol, do you have any further questions or concerns?
No objections.
Okay, so I'm going to rule that you are not disqualified and you'll stay on the Board of Appeals. Is there anyone that would like to overrule me? Thank you. Any other Councilmember Demas?
The only thing I have is that I also watched the meeting, but I haven't spoken with anyone one-on-one or had any communication with anybody.
And just to clarify, do you think that makes you in any way unable to sit and have an unbiased decision on this board?
No, I do not think it
Okay,
does.
thank you. Carol, I'll start with you if you have any further questions or objections.
No objections.
Thank you. I'll now go to SeaView.
No objections.
Okay, thank you. I'll roll that staying on the board. One last look around. Okay, great. So,
Before we move on, I'd actually like to circle back to the discussion about whether or not you, Madam Mayor, may have a bias here.
okay.
After
Here, let me
seeing-
pass the gavel really quick. Yeah.
After hearing further instructions and guidance from Attorney Brooks, Chairman regarding what the standard is here, I would like to ask a few more questions.
Yeah, that's fine.
Do you, Madam Mayor, believe that you can be unbiased here tonight?
Yes, I do.
Is it true that you believe that neighbors in the community should have been surveyed before SeaView moved to purchase the property?
No, not surveyed. Some of the, I can tell you where that's stemming from. So my conversations with SeaView was at the other location that they should have talked to the neighbors about how things were going, how things were, you know, like, are there any concerns, how are we doing? And that was one of the suggestions I had for the new location also. So I don't know if not surveying them for permission, but as the operations continue, just checking in with them and making sure everyone's being a good neighbor.
Is there any requirement that SeaView do so?
No, there's absolutely no requirement.
Have you recommended that a survey or something similar be done by any other businesses in town?
Well, sure. I mean, I think that, you know, just personally as a business, I check in with, you know, for my personal work, like check in with our neighbors and, you know, how things, operations are impacting.
Have you advised any other businesses that they should do so?
You know, I guess for the city, you know, I definitely, that's my mode of operation. Like, I definitely say, hey, you should be going out and asking businesses questions and not just waiting for people to approach you.
But have you instructed any other businesses to do so, or?
You know, I guess I'm trying to figure out what you're getting at. So I didn't instruct them to do so either. That was just a suggestion.
And who is the suggestion to made to?
Well, that was during my phone call with Chris and the executive director and the clinical supervisor.
And so the suggestion, I guess I'm just trying to understand why you would single out SeaView.
Oh, and I'm sorry, I don't single out SeaView. That would definitely be my advice to any business, honestly. If you want examples of, you know, definitely that's just how I operate on my own. You know, I kind of have that expectation for the city at city locations also. You know, I'm absolutely happy to not be here and not be part of this. So, you know, we could maybe have folks rule, if they don't think I can be biased, I'm more than happy to step away and go do something else, honestly. So, you know, if you want to, you know, I'm fine if you don't think I can be unbiased.
I'm just concerned because I was informed during the other discussions that during that phone call, something to the effect of, during the first meeting, that there's a statement, it's my understanding that you made to the effect of, are we gonna wait around until someone gets raped before we do something about this?
I don't think I
referring
was
to
the one
SeaView.
that said that. I think there was someone else at the meeting that said that.
That's the information that I
Yeah.
received. So I should have changed my
Yeah, if I said, I
response to
could
the
have,
prior question and
Yeah.
say that I object, I'm concerned that
Yeah.
there might be bias here.
I mean, we definitely had a meeting, which I didn't talk about that meeting because that was having to do with that other location. So it was disclosing everything to do with the new location. I don't know if I said that. So is there a question for me?
No, there's not. I'm just going to lodge my objection to your participation
Okay.
tonight.
So I'm happy to turn to our attorney.
Thank you, Madam Mayor. The process with this, which we went through with Councilmember Cease, is that an objection has been made. Since it involves you, it would be more appropriate for Councilmember Baclan to make a ruling. The fundamental question is whether the prior conversation that's been alluded to by SeaView's representative has made you incapable of acting in an unbiased fashion on this appeal. So he gets to make that call. It's not my, call to make. And then that could be overruled by the remaining members of the board.
I am going to rule that the mayor can make an unbiased decision and does not have a conflict of interest. Does anyone wish to overturn that decision? I don't have to hand the gavel.
Okay, so now we're moving on. So I'm going to go through what the schedule looks like, and then we're actually going to approve the agenda. So each appellant has a total of 15 minutes. Each appellant may reserve a portion of their time for rebuttal if desired. Community Development will also have 15 minutes for their oral presentation in each appeal. During your presentation, the board may have questions. The 15-minute allotted time will be paused, so that's to the clerk, during any question and answer period. So I'm going to remind all parties that the board is not authorized to take any additional evidence at this hearing. The board decides the appeal solely on the evidence in the appeal record that the clerk has prepared, and that's been distributed to us ahead of time. The purpose of the argument is for each party to present that party's position on the issues in each appeal. The board will disregard assertions of fact by a party in oral argument unless it is supported by evidence in the appeal record. So oral argument will proceed as follows. The appellant will go first. After the appellant has completed their presentation, Ms. Wild will have 15 minutes in each appeal to argue as the appellee. If the appellant has reserved time for rebuttal, the appellant will present rebuttal after Ms. Wild completes her presentation. If any party has not used their allotted 15 minutes, they may request permission to use the remaining time to present additional argument. The chair will decide whether to grant any such request. After each party completes their presentation, there will be an opportunity for members of the board to ask questions, and there will be a final opportunity for the board to ask questions at the conclusion of both parties' presentation in each appeal. The city attorney may also ask questions of each party. Please be aware that the board's goal is to be sure that we get an opportunity to hear the whole argument and make a well-informed determination. Thus, the board may deviate from this presentation approach and agenda if we find it necessary to do so. So, the other thing you have in front of you is the agenda outline. And I need a motion and a second to approve the appeal procedures and the agenda. So the procedures as I outlined and the agenda that's in front of you. And I need a motion and a second.
I make a motion.
Motion made by Cease,
I'll second.
seconded by McClure. And Madam Clerk, if we could call for a vote, please.
Approval of appeal hearing procedures and agenda for both appeal hearings. Cease,
Yes.
DeMoss,
Yes.
Osenga,
Yes.
Baclan,
Yes.
McClure,
Yes.
Terry.
Yes.
This has been approved.
Thank you. Next is we're gonna begin our oral arguments for the first Board of Appeal, and that will start with Carol Griswold. We'll start with you, Carol. You can start with your opening arguments, and the clerk is gonna manage the clock.
Very well. First, I want to thank the Board of adjustment for their service. The clerk's office, in particular, Mrs. Stallard, for stepping up to this challenge, and Attorney Chandler for his clear counsel. Second, I want to clarify that my appeal point on the improper public hearing posting was not part of my appellate statement starting on page 7 of the record of appeal, though both Community Development and SeaView tried to address it. I was advised to remove anything requested or received after the April 6th public hearing. Third, I would like to reserve any remaining time for rebuttal. My appeal is based on existing Seward Code. I served for 9 years as P&Z Commissioner, including Chair. I received a shiny gold pan for my excellent leadership and dedicated service. I stand by all my thoroughly researched and documented points of appeal based on the facts of the code, which are presented in my appellate statement. The personal attacks and bullying language in SeaView's rebuttal are inappropriate. The need for treatment of drug and alcohol abuse with co-occurring mental illness conditions has swept across the nation and has caught the Seward zoning code unprepared. We have no definitions or land use plan for behavioral health treatment issues, including recovery housing and substance abuse treatment. As many public and commissioners suggested, the community needs to address this omission and decide where these uses fit in our community and code. Until then, our code's unlisted use procedures should have been followed for SeaView's requests. The Community Development Department, CDD, rebuttal acknowledges that recovery housing and substance abuse treatment are unlisted uses, but did not present that information or the correct code procedure in the resolution for the Commission. Consequently, the Commission did not address the 3 unlisted use conditions or provide the required written decision addressing each. SeaView's rebuttal failed to note that omission as well. References to the American Planning Association Policy Guide, the Planner's Dictionary definitions, Webster's Dictionary, and Robert's Rules of Order in the CDD's rebuttal were not provided in the resolution or packet for the Commission as guidance and are not in our code for commissioners to follow. The CDD rebuttal does not address or justify the emphasis of the resolution on a multifamily dwelling use. Remarkably, the CDD now tries to justify approval based on unlisted uses and speaks for the Commission after the fact. The CDD and SeaView choice of auto commercial as an appropriate zoning district for these uses is debatable. Forest Second is not an auto commercial district. It is a single lot surrounded by residential uses, left over from the former garage and gas station that should have been rezoned long ago. The definition of AC does not purposefully include residential uses. Its activities require substantial outdoor activity, traffic, and parking, which serve nearby residential areas. Perhaps the institutional zone, which includes healthcare facilities as discussed by the Commission, would be more appropriate, but this appeal is not the venue to decide. SeaView argued that the multi-family dwellings are not allowed in the institutional zone, again refusing to recognize that recovery housing and substance abuse treatment center uses are not multi-family dwelling uses. As the public and commissioners suggested, the most appropriate district for recovery housing and substance abuse treatment should be explored and discussed in public meetings and in public hearings before the Commission. I addressed group homes, convalescent homes, and clinics in my appeal points and the reasons they cannot be considered uses or analogous uses in a multifamily dwelling. Rather than repeat my other points of appeal, I would like to highlight the approved 8-space off-street parking plan, which violates Seward Code, fails to provide ADA parking, and is insufficient to accommodate the required off-street parking spaces for this large multi-use facility. The lack of ADA parking is even more surprising given the emphasis on the Federal Fair Housing Act and Americans with Disabilities by both SeaView and the CDD. SeaView did not explain why they are exempt. They are not, and CDD did not justify the omission. As noted, the off-street parking spaces per unit were incorrectly calculated, and no parking spaces were included for either the 24/7 staff, the clinic staff, or outpatients. The parking plan on page 61 of my appeal is not just a hypothetical car shapes arranged on paper. The plan has to follow code and work in reality. The facility doesn't even have room for 8 off-street parking spaces. Vehicles cannot block or be blocked. Minimum aisle widths and traffic aisles are required to avoid hitting the shed, fuel bollards, or other vehicles. All maneuvering must occur on the property. These points were not addressed in either rebuttal. Determining the number of required parking spaces based on the applicant, SeaView's, opinion is not valid. A possible similar use is healthcare facilities, 1 space per 2 beds at maximum capacity, plus 1 space for each employee on duty. With 20 beds plus pull-out sofas, that would be at least 10 spaces, plus 2 to 3 for each 24/7 staff, plus 2 to 3 for the clinic, or 14 to 16 spaces. And of course, at least one of those spaces is an 8-foot wide, van-accessible ADA parking spot. As the 24 staff are always there, overlapping at the 3 shifts changes as well, they will also always overlap with the clinic use. The code doesn't know whether or not residents will have vehicles parked there. It requires that a minimum number of spaces are available to avoid parking in the street and creating congestion. SeaView finds none of my arguments for denying SeaView a CUP are persuasive, but fails to address the code issues raised in my appeal. With a sweeping statement that the facility's intended uses are fully in compliance with code, SeaView demands that, in short, SeaView must be granted a CUP without the inclusion of Section H. Without following the guidelines established for a conditional use permit, SeaView also demands with emphasis the Commission shall permit this type of use. If, as SeaView maintains, the application, CDD, adjournment statement, and resolution all explain that there will be 3 uses for the 4-unit multifamily dwelling: 1, recovery housing; 2, residential substance use treatment center; and 3, medication-assisted treatment center, why weren't parking requirements for each included? The definition of a multifamily dwelling does not encompass these behavioral health treatment issues as addressed in my appeal. I included the previous 2019 CUP for a fourplex, as it was included in the background and justification for this CUP. That CUP is very similar to the format and reasoning for this CUP without considering the vastly different uses. The CUP is not transferable, but much of the content of the resolution did transfer. Also, the 1997 as-built included in the 2019 CUP was more current than the historic 1997 as-built included in SeaView's application, which still shows the garage where the Unit 3 is now. Neither are suitable documents for the application site plan. As for public safety, health, and welfare, the public comments are not based on misconceptions and bias. There are numerous entries in the Seward Journal Public Safety Report regarding the SeaView Recovery House on 6th and the group home on the lagoon. Last week's paper, in fact, had 2 entries requiring a police response. A random search of 3 papers in my recycle bin showed entries for February 10th and April 28th. The July 2020 felony fugitive escape was very real. The incidents are underreported, if anything. If SeaView, the CDD, and police feel that this facility will not adversely impact the surrounding community or have a negative effect on neighborhood safety, then SeaView's quarterly reports on criminal violations and annual public review required by Condition H will prove these are unfounded myths and fears. Federal Fair Housing Act. I researched SeaView's referenced court cases. The FHAA's reasonable accommodations provision prohibits the enforcement of zoning ordinances and local housing policies in a manner that denies people with disabilities access to housing on par with that of those who are not disabled. In Hubbardston's Inc. versus Township of Brick, the particular zoning question allowed planned residential retirement communities, and the court ruled that the proposed nursing home was a similar use and would not impose undue financial or administrative burdens on the township or fundamentally undermine the zoning scheme. The nursing home is on a 33-acre parcel with 6 to 7 acres for the structure and parking, and the rest for green space and landscaping. cramming the SeaView multi-use facility onto a single lot zoned AC with multiple code violations is not a violation of FFHA. A multifamily fourplex alone requires 10 parking spaces based on the site plan, unit dimensions, and should also not be permitted. The lack of ADA parking surely is a federal violation. Enforcement of our code does not deny people with disabilities access to housing, as in the Oxford House case. Our code was updated years ago so that a group of unrelated individuals can be considered family. Our zoning code does not limit where a group of unrelated individuals can rent a house, whether able or disabled in that regard. SeaView's arguments that reversing the Commission's decision would be a clear violation of SeaView's federal and state rights is another instance of bullying. The suggested time frame of 6 months to hold public meetings and address where behavioral health facilities belong in our code and land use plan is a reasonable course of action. This is definitely an affirmative step to change rules or practices that the community and commission are willing to tackle. Conflict of interest. The CDD elaborated on conflict of interest, referencing additional resources not available to the commission and not part of our code. No evidence was provided by either CDD or SeaView that Commissioner Ambrosiani had substantial financial interest, which is part of our code. However, I found the Ethics 7 Planning Conflicts of Interest reference of interest. One of the 3 most common conflicts of interest is 2, when a member is a relative of an interested party. Grace Williams self-identified as the Secretary-Treasurer of SeaView Community Services Board of Directors when she provided public testimony. Chair Eklund did not disclose that she is the mother of Grace Williams, though, to be transparent, she asked Commissioner Ambrosiani if he had a financial interest. Like Chair Eklund's strong support of the CUP, even when confronted with clear evidence to the contrary, be tainted with prejudice and put in a position of deciding between public duty and private interest? Robert's Rules of Order also provides no member should vote on a question in which he has a direct personal or pecuniary interest not common to other members of the organization. No other commissioners had a daughter serving on the applicant's board of directors. I respectfully request that the Board of Adjustment, upon due consideration, reverse the commission decision in its entirety. Thank you.
Thank you. How much time does Carol have left?
5 minutes.
5 minutes. Okay, Carol, I just wanted to check on that for you. Now we'll go to community development.
I just have one question. It was at 290. It was 239 is what the clock was at.
2 minutes and 39 seconds.
Okay. So Carol, did you hear that update? You have 2 minutes and 39 seconds remaining for your rebuttal.
Okay.
Okay, thank you. All right, I'll turn it over to you. 15 minutes.
And I choose to keep any time left after for rebuttal, please. Mine's going to be pretty short and sweet. A big portion of my rebuttal that was included with the commission or to the Board of Adjustments, a big question was whether or not the CUP should have even been brought forward to the council or the commission at the time. You know, it is my job and my department's job to review the code to see if where things fit, how they work, and how we would describe them. And so our office met with the SeaView Community Director multiple times before this CUP even came forward, talked about areas in town that they could purchase. Auto commercial seemed to be coming up quite often. And then they discussed what they wanted to do if they were able to purchase a building. Because they discussed that with us, you know, at the time, because we had had previous conversations about the 6th Avenue, I felt that it was our best interest to bring it forward in a CUP and as a mixed use, because they had a lot of things going on. It wasn't, you know, we were gonna just do recovery, they were gonna do a clinic and everything later on. And I just made the suggestion that we look at it as a mixed use and that we bring it forward to the commission in that state. You know, at any time, if they would have called it a clinic, we wouldn't even questioned it. We would have got a business license for that location and would not have required them to come forward. They would not have had to justify or say what they were doing on their property, because that is not what planning and zoning, we follow the code. And I personally really pushed for them to fill this CUP out. It was because I wanted it to be open. So did SeaView. SeaView wanted it to be, you know, everybody to acknowledge what was happening, because they didn't want to get down the road and be treated like they were on the 6th Avenue property. So I know that thing kept going back and forth, and it is questioned by Ms. Griswold whether or not this, you know, is the way that we look at it. The Planner's Dictionary, APA, all of those things are available to our commissioners. But it's my job to help initiate them. So when we look at something, we look at how other cities do it. We shouldn't recreate the wheel. Look at how other cities define things, how the statistical data works, and then base it off of how a conditional use is. So I use the American Planning Association quite often. They're a great resource. And any of the commissioners at any time can ask and log in to the same thing, Planner's Dictionary. I brought it up multiple times previous to this meeting. At the meeting, they kept going back and forth about one word. I don't like the way this description is for convalescent. Well, we need to change it. And I brought them back, reminding them that their goal, and I say our goal is as a city, but their goal as a commission is to look at what is in front of them and is the use allowed, and is it allowed by CUP, and are they allowed to put restrictions on it? They went back and forth on their restrictions. As far as discussing the parking, if based on the parking requirements to any similar use, our requirements have been met, because a multifamily 2 parking places per dwelling equals 8 spaces. A multifamily dwelling institutional is 1 space per unit, which would have been 4 spaces. Dormitories, bunkhouses are 1 space per 4 residents, which would have been 5 spaces. So that's where it comes in. We look at it as a mixed use, and we maneuver. It's not that we're circumventing, we're figuring out, is this how we want to require parking? Is this how we want to look at this building? They could have, even in the CUP, we could have put in the title alone that it's a mixed use. We didn't have to list everything that we did in the title. I also want to point out that it is impossible, and I've said this at the meetings, for us to put every definition in the code. If we put every definition in the code, we're going to have a code book of the Webster's Dictionary. And it is, we established how to make a decision on calling it a multifamily or housing and convalescent home. We also reviewed back at the previous CUP. It was not transferred. Nothing was transferred from the previous CUP. The wording probably is pretty close, because again, there's no reason to recreate a wheel when you're already doing resolutions and agenda statements. And I'll hold the rest of my 9 minutes and 8 seconds to rebuttal.
Carol, we'll go to you for your rebuttal with your time you have left.
Thank you. Again, I saw no mention of the lack of ADA parking. It's pretty incredible that this is not included for this facility. In my written statement, I analyzed the parking. It was just amazing to see how space 2 blocked by space 1 and 3. This was not addressed. House space 4 has to go around the shed. House space 8 has to avoid the fuel bollards. Space 1 has to back into the public right-of-way to turn around. It's a completely infeasible parking plan, and it has no ADA. It's not, that should sink the thing right there. So I'll reserve some time if that's possible. Thank you.
I don't know if there's, so stop the time. I'll just check with the attorney. Is there a second round of rebuttal until time runs out?
Not usually.
How much time do I have left, please?
1 minute, 57 seconds.
So Carol, we'll have you use the rest of your time at this time if you'd like.
Okay. I'm sorry, I can't condense all my objections into that short of time, so I will pass. Thank you.
Okay, thank you very much. So we'll turn it back over to community comment.
9 minutes. Take 9 seconds. So in answering to the parking issue and requirements, when we're looking at the parking plan in general, when reviewing, you'll see that there is a carport that has 2 spaces in it. It is no different than any of the townhomes that have the ability that we count parking spaces. You know, somebody parks in a garage and then turns around and parks right outside the garage door. That's considered 2 parking spots. So we count that as the 2. In many talks with SeaView, the layout was something that we spoke about, and my understanding was the carport was going to be used for their staff. So if anybody else that would have cars would have parked out in front. I also want to state that multiple family dwellings is a building designed for 3 or more families, with the number of families in the residence not exceeding the number of dwelling units provided. As our code states in 1510-140, an apartment, commercial building, an apartment is an apartment located within a building designed to accommodate a mix of residential and commercial uses. Our land use table allows dwellings as apartments in commercial buildings, 2 or more units. That is an allowed outright use. Dwellings, multifamily, 3 or more units is allowed by conditional use. Housing, nursing, retirement, convalescent is allowed by conditional use. Office, business, professional is allowed outright. Business, retail, sales, and service is allowed outright. And a medical clinic is allowed outright in an auto commercial district. A conditional use permit has not been transferred. As I said before, we do reuse the template, but it was nothing in that was a transfer of a previous conditional use, which was approved for multifamily dwelling. I also want to provide 1510-115 of our city code. Purpose 8 is to provide for orderly and stable public residential, commercial, and industrial development. The location in the area is near a business district with pedestrian and vehicular traffic. However, very few, if any, of the residents would have vehicles, as was reported at the meeting and in their application. That's all I have.
6 minutes and 7 seconds.
Thank you. So that gave time for opening arguments for each party, rebuttals for each party. Now we're down to questions from the Board of Adjustment, if there are any, and those questions can go to either party. Do we have any questions? Let's pause and make sure folks have a chance to review their notes to see if there's any questions. Councilmember Demas?
Can you review the ADA parking again, was that not allowed or not required because of a multi-use, or is there ADA parking?
In our code, we just list parking spaces. We don't, I mean, their layout did not show the ADA parking, but we just counted how many spaces they would need, and I'm sure that they were going to make one of them ADA. I don't know the way that we looked at it.
Okay, thank you.
Vice Mayor?
So our code does not specifically say you must have one ADA spot per X many spots.
I'll just confirm. No, we do not have it in our code that says it is required.
Any questions? Councilmember?
I guess I just.
Oh, I take that back. I'm sorry. I'm sorry. Accessible parking requirements. All parking shall apply or comply with the American Disabilities Act. It doesn't specifically state the dimensions or anything.
Is that, I'll check with Councilmember Demas. Did you have a follow-up or a separate question?
I have a separate question.
Go ahead.
Can I follow up on that
Oh,
specific
do you
question?
mind?
No, no.
Okay, Vice Mayor.
Is there, within that space, is there, of the planned parking, is there space for an ADA accessible parking?
Yes, sir. When we're looking at it, we give them the number, so we gave them 8 parking spaces. And, you know, previous apartments that have been built, previous things that have been built, we just count them as how many you need, and then they turn one of them in or 2 of them into parking and into ADA. But it's not, we don't sit there and say, well, you need to make sure. We just tell them that they have to have 8 spots. They need to have 8 parking spots, and, you know, we never had a parking plan that's like, this is really specific, this is where the ADA is gonna be, so.
And just to
I'll
follow up.
let you have the follow-up.
Right, on from that, do we, as a city, monitor ADA parking, or is that on a private citizen or an entity to then say, you do not have ADA parking?
Yeah, we don't monitor it. I mean, we don't go out and make sure that every place has an ADA parking, or every residence that has, you know, the need for ADA parking. In our community, on our streets, you know, we do have designated ADA requirements for our sidewalks, and our parking there is marked.
Said, okay, what is this closest to that is in the table? And they determined that that was a multifamily dwelling, and so they analyzed it under the multifamily dwelling. But because it was a mixed use, they also analyzed it under the 2 other proposed uses, one of which was an outpatient clinic, and then there's something that's similar, I think, that combines perhaps outpatient and residential treatment to help people recover from substance abuse issues. So the planning department took that first approach to it, but that wasn't the only option available to them. And so I think one of the points that Ms. Griswold is making on this appeal is that this other option is the one that they should have taken.
Thank you.
Yeah.
Are there any further questions? I'll pause for a second, just to be sure. Vice Mayor?
What, I'm trying to find it, and I know I read it in here, but can you just say for us again what our code says about unlisted uses?
Yes, it's in 1510-130, unlisted uses. Unlisted uses may be allowed within a district upon written decision by the commission, provided that each unlisted use meets all of the following conditions. Number 1, the use is not specifically permitted in any other district. Number 2, the use is not more appropriate in another district. And number 3, the use is consistent with the purpose of the district in question and is similar to other uses permitted outright.
Could you read the second one more time?
Yes, second is the use is not more appropriate in any other district.
Can I ask a follow-up?
Go ahead, please.
On top of auto commercial, what is it then industrial?
Or the way
I'm-
that the list
yeah,
is.
kinda, yeah, I'm sorry, going, yeah, right. So you're looking,
Yes,
so industrial.
industrial.
And then after industrial is at the end?
It goes, I have to say them all, I'm sorry. It goes rural residential, R1, R2, R3. Oh, you are, I'm like losing my mind. All I see is colors, I'm sorry. So I'm like, you are, then it goes into OR, auto commercial, industrial, institutional, and then resource management.
In institutional right now, currently where is the zones? Is that just like the AvTech area that's by Second Lake and then?
A lot of and there's a map behind you guys, a lot of the gray areas are institutional zoned. They're hospitals, they're city offices or city properties, and the school area.
Are there any institutional areas that are not currently not used?
Not used for,
Is that Fort Raymond? Is that
Fort Raymond is auto commercial.
auto commercial? Oh, that little red lot.
Yeah. The piece right off of the highway there that is owned by the city, is a vacant lot that is zoned institutional right now because it's owned by the city. Did you have a follow-up?
Thank you.
Are there any other questions? I have one question. So, looking at the definition of a medication assistant treatment clinic, would that include or encompass overnight, or is that a day use facility?
From my research, there was a variety of, when I looked at them in a larger scale, in larger areas, there were areas that had, some housing attached to them, but, not knowing what exactly is being used in the clinic or how it was going to be operated, I based my decision and discussion and request for them to do the CUP off of that. When somebody's standing in front of you saying, we want to do this, 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 and this, my first and foremost is, that's a mixed use. Now how do we figure out if it's doable or if it's allowed?
Okay, thank you. We'll just check one last time. Are there any other questions? So,
Madam Mayor, I had some
Go ahead.
questions. And this is for you, Jackie. My understanding of Ms. Griswold's argument is that the parking should have taken into consideration that some of the units were larger than 1,000 square feet in size, because the parking requirements in the code add a half space per unit that's more than 1,000 square feet in area. And I'm wondering if you have evaluated her argument and have any response to that.
I read it. I went back to how we calculated the 8 spaces were going to be needed. Off of that, previously, the larger apartment was, in the previous CUP, when it was requested as a multifamily unit, we discussed that at that time, broke it down, and that's where we came up with, they had one unit that was over a half of a parking spot would have been required, which would have bumped it up to 1. And then during that CUP and previous CUPs, not even regarding this property, it has come to the commissions of looking at exactly the use and whether or not they're gonna go by 0.65 for the calculations of a parking spot or 1.15. And they've moved more towards doing a 0.65 on their requirements and requests. So when we break down the square footage and everything, we break it off of a 6.5 breakdown.
Do you mean you take 65% of the indicated square footage of the unit on the drawing?
No, we take the overall square footage of the property where they're wanting to do parking, and we break, instead of doing it, you know, let's say it's 80 feet and we do it by 1, we do it by 0.65 to do our
Okay.
calculations.
Did you have another question? I'll check again. Any other questions from the dais? Okay, based on that, I'll conclude the hearing on the appeal of Carol Griswold. Thank you, Carol.
Thank you very much.
Have a good night. So next on the agenda is the oral arguments appeal of SeaView Community Services. And we do have this table set up for you if you'd like to come sit at this table at this time. And that'll get you mic'd. And so again, we'll follow the same pattern. We'll do, yeah, both of you are welcome. And actually, we can move more chairs up if you want more people sitting at the table. But while we're doing that, I'll check, does anyone need a break? The only concern I have with cutting for a break is there's no talking. So is there anyone at the dais that needs a break, or should we continue? Okay, we'll let you guys get settled. Unless you yourselves wanted a quick break. Okay. Thank you, though. Yep. Yep, and just grabbing water. So again, the 15 minutes, we'll start with SeaView Community Services. Any time remaining from that 15 minutes will be yours to utilize for a rebuttal, if you have a rebuttal. And Madam Clerk, when they start, are you ready for them to start when they're ready? Okay, just when you're ready to start the time.
Good evening, everyone. My name is Sienna Caruso. I'm an attorney from Dorsey & Whitney, and I'm here representing SeaView Community Services. For the record, sitting next to me is Christine Sheehan. She's the CEO of SeaView Community Services. We are here today appealing the Planning and Zoning Commission's inclusion of Section H in the conditional use permit that was granted in Resolution 21-008. And just for the record, I'd like to reserve any time I have remaining for rebuttal. As many of you know, SeaView provides critical behavioral health services here in Seward. There is additional unmet needs as demonstrated by 2008 Providence Community Health Needs Assessment, and they were granted $150,000 to the Alaska Mental Health Trust, recognizing that there is additional need here in the community. So that is the desire and impetus for purchasing the building at 402 2nd Avenue. The purpose of including this building is to provide a continuum of services here in Seward for members of the community who have trouble with addiction. So those who are in crisis will go to detox in another location, in, for instance, South Central Foundation in Anchorage. Once the detox is complete, then if they are selected, voluntarily selected, mutually selected by SeaView to come and receive services, there will be a continuum of services from intensive residential treatment, then to recovery housing, where they will be encouraged to be employed and be productive members of the community, then to sober living facility, and then finally, the hope is independence, where they can have the support and structure here in their own community to be successful after they go through treatment. As you heard in the prior hearing, SeaView applied for a conditional use permit at the recommendation of the community development director, and that conditional use permit was appropriate. To the extent that there's concerns regarding parking, as was mentioned in the briefing, SeaView is prepared to provide an updated schematic of 10 parking spaces, one of which will include an ADA parking space. So if that is something that the Board of Adjustment is interested in, please let us know and we can provide that. One other note is that there was no conflict of interest with regard to Chair Eklund. Her daughter is, in fact, a board member of SeaView, but board members on SeaView do not receive any compensation of any kind to be a board member. So there is no conflict of interest there. And, you know, although it was granted auto commercial zone, and there were concerns that were raised about that, there is no more appropriate location. As the community development director mentioned, this is a mixed-use facility, so it needs to have both clinical capacity and residential capacity. And that's why the AC zone is a perfect location for this facility. I'd like to turn now to the issues with Section H in the conditional use permit. So there's actually 3 issues with it. First, it's unclear what is actually required of SeaView. It mentions a 1-year review. For what purpose? It mentions a public hearing. There's no basis on which explains why there would need to be another public hearing. And it requires SeaView to provide some sort of quarterly reports, but doesn't explain what needs to be in those reports. And a lot of that information might actually violate the privacy rights of residents in SeaView's facilities, and SeaView may not even be permitted to provide that information under HIPAA. So there's a lot of concerns regarding total vagueness in that provision. The second issue is that it's absolutely unnecessary. The concerns that were raised with regards to enforcement of a conditional use permit, that is within the purview of the community development director. That is her job, to enforce conditional use permits, to modify them, remove them. There is a process for that. And so that is really within her wheelhouse. Separately, the concerns that were raised regarding potentials for crime or potential nuisance issues, that is within the purview of the Seward Police Department. It's not within the purview of the Planning and Zoning Commission to be a super police power here. That's not their job. The job is to determine whether or not the uses that are being applied for in a conditional use permit conform with the code. And as the community development director has explained, they do here. So the first issue, the Section H is absolutely unclear. In fact, it's grammatically unclear also. It's unnecessary. And so the third and the biggest issue is that it violates both SeaView's and its future residents' rights under the Fair Housing Act, under the American with Disabilities Act, under their rights under the Alaska Constitution for equal protection, and under the Alaska Human Rights Act. So the Fair Housing Act and the the American Disabilities Act deems it unlawful to discriminate in the sale or rental or otherwise make unavailable or deny a dwelling to any buyer or rentier because of a disability. So that dwelling here is SeaView, and they qualify as a dwelling because they are a sober living facility. And the disabled individuals are the residents who will come, individuals who are recovering from drug and alcohol addiction. They are classified as disabled under federal law, and so they are granted these protections for the exact reasons that we've seen in the hearings, having a small minority of very vocal community members who don't want a facility like this in their backyard. Seward is not the first place where these concerns have been raised, and courts across the country have said this is exactly why these federal laws are in place. So a handful of community members cannot protest and result in the violation of other individuals' rights, federal and state rights. So there's 3 reasons why Section H violates the Fair Housing and American with Disabilities Act. The first is that it was born out of discriminatory treatment and intent towards the individuals who will be in the facility. The purpose was to create an overly restrictive and onerous condition placed on SeaView because it is a sober living facility. So because it was placed because of the purpose of this facility is how it violates these 2 federal laws. And, you know, in fact, this was a condition that has never before been placed on any other business, as was discussed at length during the hearing. And the commissioners in the hearing recognized that by placing a condition like this, it could open up the city to a lawsuit. And they were absolutely correct, because courts have repeatedly said that decision makers, like the commissioner, like the Board of Adjustment today, like other city officials, have a duty not to allow illegal prejudices of a majority to influence the decision-making process, and that it is unlawful to cater to their constituents' bigotry. And unfortunately, that is what we've seen here today. There is a minority, a very small handful of individuals here in Seward who, because of stigma and because of discriminatory misconceptions about the individuals who will be in this facility, are trying to have something that would otherwise be permitted under the code be blocked. So that's the first reason. The second reason is that it has a discriminatory impact. So this is being placed on SeaView because of its status as a sober living facility. It is requiring that SeaView submit to annual review, additional public hearings, and quarterly updates that would hold the facility's future tenants up to public scrutiny in a way that is not required of any other businesses, and particularly any other businesses that don't involve individuals with substance abuse issues. And it would also further inflame opposition to this brand new requirement that's not imposed on any other business here in Seward. And the last is that the condition violates the Fair Housing Act and the American with Disabilities Act because it fails to provide a reasonable accommodation. As Carol Griswold mentioned in her oral argument, cities cannot refuse to accommodate by imposing unreasonable conditions on the grant of a use permit. So Section H is unreasonable because it turns what would otherwise be a reasonable condition, the granting of the CUP, into an unreasonably restrictive and burdensome accommodation. And in fact, it jeopardizes the longevity of SeaView and the success of the facility. As Chair Eklund mentioned in the hearing itself, she said, if I was a person investing in it and it was on a 1-year lifespan, I probably wouldn't want to be an investor. So that just goes to show that Section H, the intent by the commissioners when they decided to implement Section 8 was to create black box, vague requirements to justify their revocation of the CUP in 1 year, because they recognized during the hearing that they were unable to retroactively zone the area to prohibit the facility from being placed there. So instead, they tried to work their way around that by adding this condition. And that is exactly what is prohibited by the Fair Housing Act and American with Disabilities Act. Additionally, it's violative of Alaska state law, the equal enforcement protection under the Alaska Constitution, and also Alaska's Human Rights Act, which prohibits municipal governments from discriminating with regard to housing. So therefore, SeaView requests that the Board of Adjustments, under their authority in 1510-430B, modify the CUP by striking Section H. We're specifically asking that the Board of Adjustment use their authority to do this rather than remanding it to the Commission, because the Commission has been tainted by the conflict of interest of Commissioner Ambrosiani. in the discussion about whether or not he has a conflict of interest, which we looked at length today in this very hearing, he only mentioned the potential conflict of interest with regard to his B&B property that was in the neighborhood, and said, contrary to the testimony that was provided by his wife, that he wasn't sure whether or not it was going to impact his property values. All but the fact that he then went on to provide a litany of reasons during the hearing as to why he felt like the inclusion of, the permission of the cup would negatively impact his property values. But the bigger issue, the conflict of interest at play here, is that he is the executive director of the Seward Community Health Center, which directly competes with SeaView because they both provide behavioral health services. And so the services that SeaView provides will detract or limit the services that his organization will be able to provide. And he, as executive director, is compensated for his role in the success of the Seward Community Health Center. So there is a direct conflict of interest there. It was not disclosed, and as demonstrated by the spearheading effort in which Commissioner Ambrosiani had to first not allow the cup, and then when he realized he couldn't prevent the cup from happening, imposing this brand new, never before used, recognized that it might violate the rights of SeaView and its future residents, new provision of Section H. So returning the decision of whether or not or what to do with the cup going forward, remanding it back to the commission would be absolutely improper, because the commission in its entirety is tainted by Commissioner Ambrosiani's vocal and outspoken arguments during the underlying hearing. So in closing, again, the SeaView community, SeaView requests the Board of Adjustment tonight exercise its authority to remove and strike Section H from the cup, and that it issue its decision as soon as possible, but no later than May 24th, so that SeaView and the sellers have enough time to exercise their rights and meet their obligations under the real estate purchase agreement by the July 21 closing date. Thank you for your time.
Turn it over to community development.
Community development has no rebuttal.
Are there any questions? Yes, ma'am.
I know that we had just gone over our conflict of interest, and I know that there was guidance sent to us by our attorney. The first part of the conflict, addressing conflict of interest, was the may or may not. And if at that time there was no decision before the vote, would Commissioner Ambrosiani have, this is separate from the other part of conflict of interest. So the first part, meaning the may or may not, his property being affected if they were granted a CUP, if SeaView was granted a CUP, the same as us, if he was or was not, if he didn't know what was going to happen, did he have a conflict of interest at that time?
So you're asking a question to me?
Yes.
Okay. Well, I'm going to ask a question of counsel for SeaView, because I've been wondering about that myself. So is it your position that there was a conflict of interest due to ownership of the property across the street?
Yes, so it's SeaView's
So
position.
why do you say that was a substantial financial interest?
SeaView believes that there was a substantial financial interest with regard to the property because by Commissioner Ambrosiani would have been incentivized to not, based on his views, that SeaView would result in the diminution of value of properties in the area based on assumptions made by people in the audience. Because of that, that would be a conflict of interest, because he believed that if SeaView was granted the cup, that it would diminish the value of his property. And so he had a substantial financial interest in denying the cup to ensure that his property values, in his opinion, would not be diminished.
But I thought it was SeaView's position expressed with documentation provided to the Planning Commission that granting the CUP would have no impact on property values.
So
Wasn't that the position that SeaView asserted?
that is the position that was asserted, and that is the position that's supported by the property assessment that was done by Seward Properties. But Commissioner Ambrosiani, in his own mind, when deciding whether or not to grant the CUP, it was his perception, as demonstrated by his wife, who came and vocally testified, that he believed and they believed that their property value would be diminished because of the property. So whether or not that's a valid belief, I think, is irrelevant, because it was a belief that he had, that they had, and even though he mentioned during the discussion that he wasn't sure, that he thought that it would be a negative impact, but then he did some research and maybe it wasn't, but he wasn't really sure about it, I think that that is still sufficient to demonstrate that his personal belief was that his property values would be diminished, and so it would incentivize him to want to deny the conditional use permit.
But are you aware that our code defines substantial financial interest not based on belief, but on actual pecuniary gain expressed in terms of dollar amounts?
Okay, but even if that's true, then the alternative position is that he was biased, as I discussed during my argument, because of his involvement as executive director in a competing business. And so he stood to substantially, have financial gain.
Let me ask you
by
about that
limiting.
then. Is he the owner of Seward Community Health Center?
He's the executive director.
Okay. Is there any evidence in the record that his compensation as executive director is directly related to whether or not a CUP was granted to your client?
May I concur with?
Sure.
So there may not be evidence in the record specifically on that regard, but the fact that he did not disclose that prior to the discussion and prior to the conflict of interest vote is also a violation.
Also, there were 2 votes taken. The first vote was on amending the proposed resolution to add the condition that you have asked be removed by the board on appeal. And then the second vote was to approve the CUP as amended. So if Commissioner Ambrosiani had a conflict on the first vote, did he also have a conflict on the second vote?
Yes, I believe he had conflict on both votes.
And therefore,
And there's emails to that effect of understanding what the deadline will be to file an appeal. Yep.
Look around for further questions. Pause. I have a question. To your knowledge, do you know, does the CHC have any residential treatment facilities in Seward?
And that being the community health center.
Yeah.
At this time, they do not. They have just behavioral health services, similar to some of the services that would be provided at 402 2nd Avenue. Whether or not they have plans to expand, perhaps.
I guess I'd like to get on the record, if concerns are brought to SeaView, I guess I'm just assuming as previously has been demonstrated that SeaView would talk and address those concerns, if there's any concerns brought to them by the neighbors?
Yes, absolutely. And, you know, I hope it came across, you know, in both in our briefing and in our argument here today that, you know, SeaView is doing everything it can to be as transparent as possible. You know, as the community development director mentioned, you know, questionable whether or not a cup was required, but wanted to go through that process to make sure that everything was above board, that all the I's were dotted and T's were crossed. And so with regard to, you know, any concerns that might come up either with regard to the cup, absolutely, we'll work with community development director, we'll work with the neighbors in the community, and of course if there's any criminal concerns, you know, we'll work with law enforcement as necessary. You know, SeaView is here to provide much needed services to the community. They're here to help provide support to those who need it the most. And they want to be part of the solution. As Chief of Police Nichols mentioned, you know, the concern here is not those who are in recovery, you know, with regard to criminal concerns. It's those who are still suffering from addiction. And so SeaView is part of the solution in this community to help those who are ready to seek treatment, to obtain that treatment, to be able to do it in their community and create successful foundation and coping skills to maintain their rehabilitative status going forward.
You know, so I just have a follow-up to that. So maybe could you help provide for the record, like what, I mean, I know it's a little bit intangible, but if a concern was brought to SeaView, you know, not through the criminal justice, but concern was brought through SeaView, what would be some of the steps that would be taken?
Sure, and because it's a more factual question and is sort of a little bit outside the scope here, would the Board of Adjustment mind if Chris Sheehan provided her input on this?
I don't think there's any objections. That would be great.
Okay. Well, we would encourage people to contact either myself or our Chief Clinical Officer, Tony Clanton, who's also here in the audience, and that we would be happy to meet, discuss, to hear what their concerns are, and then of course address those that would be appropriate to address. So, and I think we've demonstrated that in the past and would certainly be doing that in the future. You know, we're looking to be a good neighbor, and so we do want to know what people's concerns are, and we'll work with the neighborhood. That's part of our model.
And I'll just check again if there are any more questions. Any questions for community development? Go ahead.
Thank you, Madam Mayor. I had a question about reporting, and I was just wondering if SeaView is required by state licensing authorities or federal funders or anything like that to submit periodic reports as to what is happening at the various facilities.
Again, I think this might be a little bit more of a fact-based question.
Please.
Yes, so we are a community behavioral health center that is licensed by the state of Alaska, DHSS, and so we are under their oversight. And they provide us with some small amount of grant funding that helps cover expenses for those people who can't afford the services. And so that funding goes to, it's kind of helps out in the community. And as a grantee of that, we have to do quarterly reporting on our activities. We report, you know, a whole variety of things that we do. So absolutely, we report to other grantors as well as our licensing oversight.
And are those reports, are they submitted in a way that's HIPAA compliant?
Yes. Yes, and we are also nationally accredited, and anyone who is in the healthcare industry knows that is a very detailed and time-consuming regular process,
and where peer reviewers come on site and they actually go through all of our programs, and they talk with all of our staff, they talk with our stakeholders. So there's quite a bit of oversight even through our national accrediting body.
And how often is that process?
So we do an annual updates with them, and every 4 years is when they come on site and do a complete site review.
Are you satisfied?
Yes, thank you.
No, I'm just checking. So based on that, thank you both very much. We'll have you sit there until we move forward. Thank you. The next item on the agenda would be to conclude the hearing on the appeal for the SeaView Community Services. And then we go into either in public or in executive session deliberations on appeals. So I am just going to go ahead and make a motion to go into executive session to include the city attorney and then all the board members sitting on the Board of Appeals, and excluding everyone else. So that's my motion.
I'll second that.
Is there any discussion regarding that? I will say, let's give ourselves a 5-minute break, but I'm going to strongly caution every single person, they're not to talk in the bathroom, they're not to talk in the hallway. So if someone walks by you without saying anything, it's not being rude. Let's just really make sure that we're maintaining the integrity of the appeal hearing. So I'm gonna actually adjourn and we'll come back at 7:25. Thank you.